Give everybody just a couple of minutes here. Not quite on the top of the hour. All right, I see that it is 1 o'clock. We have our DAG, we have our director, I'm your chair, so I figure we get the party started. So welcome everybody to the Nevada State Board on Indigent Defense Services meeting for July 9th, 2026. I will call the meeting to order at 1 p.m. and I will ask Casey, will you kindly do a roll call of our board members?
Absolutely. Just a reminder, this meeting is being recorded.
Thank you.
Kate Thomas,
I'm here.
Joni Easley.
Yep.
Okay. Chris June Kellyani.
Here.
Eric Blakey.
Here.
Susan Bush.
Here.
Angela Cook. Lorena Dellinger. Joe Krim. Allison Jaffe.
Here.
Abigail Frierson. Jared Hickman.
He's excused. Thank you.
Ben Gauman. Justice William Maupin. Judge Gary Fairman.
I show 7 of us, so we have a quorum. Okay, thanks, Casey.
Okay.
All right, let's proceed right into then public comment. We are asking if anyone would like to make comments on items on this agenda. We're not going to take any action on any matter that's raised, and please keep your comments to 3 minutes. Do we have any public comment? Franny, I see your hand is up. And you are muted.
Sorry. There
There
we
you
go.
You're good.
Sorry. There we go.
Yep.
I'm speaking as Franny, the old public defender, and not as Franny, the counsel for the Davis Group. This board has in front of it a number of items that I'm asking you to consider as urgent. You see them in the monitor's report. I have not seen the oversight attorney's report. But I know that you've been advised that the state public defender has resigned. Before that happened, the only experienced lawyer in White Pine County was terminated. And then you will also see a number of instances cited by the monitor of situations where clients are not seeing discovery. There's no vertical representation. And there's a number of things that are just simply urgent that I'm asking that the court engage more heavily on with the director. Thank you.
Thank you, Franny. We appreciate your comments. Is anyone participating in the meeting wish to speak in public comment? Any other person?
Chairman Thomas, I'm trying to figure out how to raise my hand. So,
You're good. Come on in.
okay, thanks. Um, Hi, folks. I'm John Lambros. Some of you know me, some of you don't. For the folks that don't know me, and before I get into who I am and why I want to speak, I'd like to give a shout out to Chairman Thomas, Vice Chair Hickman, for the work that they've done over the last several weeks. They just so the members of this board know. They've been doing yeoman work on behalf of the board, on behalf of of the state, and in compliance with their duties under Chapter 180. So they and of course Peter should be acknowledged and I can't tell you how much I appreciate the work that they've done in the last several weeks. Um, some of you know me, obviously, Joni, Chris G. We go back to when the days in Nevada were pre Chapter 180, and we had, by the grace of God, and I think Chief Justice Maupin for sure, and Justice Hardis.
Mr. Lambros, I think you're frozen. Unless,
17 legislature.
there you go. Okay, we're good.
And in 2019 was the committee made the recommendations that uh, ended up in the current, well, not really the current iteration, not as good an iteration of Chapter 180 that currently exists. But having said that, I'm very, I view this through a lens of where we were before Marcy Reba was so unjustifiably terminated, and my wife Laura Fitzsimmons resigned as the chair. Peter was left in an awful, awful situation, inexperienced and with only one deputy. And he should also be acknowledged and congratulated for the carnage that he's had to go through since then. And one thing Laura said in her very last meeting, and the minutes from that November 2024 meeting reflect it. Why would we not hire Peter? Nobody else is going to take this job right now. And, and Peter, I know that sounds like a bit of a left-handed compliment, but thank you very much for the work that you've done under the circumstances that you've had to do it. Um, I'm not gonna get into a whole lot of discussion about what's happened post Marcy and post Laura, but we do have some good institutional knowledge on this board. Peter, of course, has come a long way in the 18 months that he's had to travel. Chris G has been on here since day one. Joni Eastley goes back farther than anybody except me. Joni was on the Indigent Defense Commission when Judge Papez and I were the co-chairs of the Rural Subcommittee. And as Joni will echo, one thing that subcommittee recommended and that the rest of the Indigent Defense Committee signed off on, and that the Nevada Supreme Court agreed with, and that the legislature was asked to do was total and complete funding of criminal representation in the rural counties handed by the state with no county obligation for funding. And I'm going to mention something about that in terms of where I think this board can go next in terms of its recommendations. But I don't see any reason why that's a fool's errand right now, because let me tell you, those of you who remember, and Judge Fairman, I'm sure you do, the good old days before 2019, the counties were bearing 80% of the costs of indigent representation. And with all due respect to the history of the State Public Defender's Office, and I'm not talking about the most current iteration of the State Public Defender's Office, but it goes back farther than that. The counties, and you know, I have to admit, the counties correctly did not think they were getting the bang for their buck that they deserved. And this started in the 1990s and went forward. So the way I view where we are now and where this board is now is that fundamental fundamental, not changes, but kinds of maybe moving in a different direction need to be considered by this board. One thing that I think needs to be considered seriously is when a new member comes on, there should be a serious and compelling orientation session that that member goes through so the member knows what it is that they've either voluntarily signed on to do or got told that they were going to do that by some superior. Um, in the very first days of the board, the people who were on the study committee became board members, and that was in 2019. So not only was there wonderful institutional knowledge, but we were able to move forward with the chairman who was then the mayor of Carson City, Bob Kroll, a lawyer and a dear friend of mine. And after Bob finished, he was succeeded by Ann Traum, who was a colleague of mine and Franny's in the Federal Public Defender's Office, now a federal judge sitting in Reno. Dave
Mr.
Mendiola,
Lambros, if
yes.
I may, real quick, we're trying to limit public comment to 3 minutes. I do want to
Oh,
hear what you have to say. Thank you, just so we're consistent. I know
I'll,
there are, if you
I'm
could
sorry.
either wrap up or we have other opportunities for you to provide this
No,
really valuable. Okay.
I'll
Thank you
wrap
so
up.
kindly. Okay.
Here are the my bullet points. I think the board needs to be thinking about bylaws and how it is that the board can structurally help Peter better. I was a former member of the State Bar Board of Governors. We had an executive committee. The executive committee sometimes did not comprise just board members. Sometimes the executive committee would bring in other people, and in this case, maybe contract lawyers, maybe other public defenders. I think that the board needs to consider how changes in the statute creating the board might be helpful. Next, I think the board might want to consider having bylaws. So the board members understand what their duties are, which are significant under Chapter 180. I think the board needs to be more cognizant of its responsibilities with regard to the Davis litigation. I will remind those of you on the board that when the Davis settlement took place in August of 2020, Bob Kroll, then the chairman of this board, signed as a co-signer because the board was mentioned in that stipulated settlement no less than 16 times in order to implement what needed to be done in that settlement. And finally, I think the board needs to be thinking about how it is that they'll go back and ask the state for more money. Because I think the less money the counties have to pay, the more constitutional it becomes, and the less the counties will mess with the operation of DIDs. And you won't see this kind of nonsense about flat fee contracts that are coming out of Douglas County and Nye County and Lyon County. Everybody on this board and everybody under state law knows that those are not legal, and there's no reason why we should be battling those out. So, having said that, I think the board moving forward is in a really good position to move positively, but with the knowledge that these obligations under Chapter 180 are compelling and even more compelling. And as Professor Hanan has told us for the last 19 reports, the board is an integral part in seeing that that stipulated judgment comes to fruition. Thank you, Kate, or Chairman Thomas. I'm sorry I yacked so long.
You're okay. Thank you. We appreciate your comments. I'm just trying to apply this evenly. Thank you, Mr. Lambros. All right. Any other public comments from those attending this meeting? Okay, I will close item number 2, which is public comment. We will move on to item number 3, which is board related business. We have 3 items under this. This is for discussion and possible action. The first one, awkward for me to introduce, is the election of the board chair and the vice chair. Somebody's got their hand up. Sorry, iPad 92, please go ahead.
I think that's Chris G.
Oh, Chris, you're muted, but please, the floor is yours.
Okay. I was going to make a motion, Madam Chair, if you're willing still to serve, and Vice Chair Hickman to serve. Make a motion for the 2 of you as chair and vice chair to continue in that role. You've done a very, very good job, both of you.
Chris, I'll second that motion. This is Joni in Tonopah. If
Thank-
something is not broken, then let's not break it.
You got it, Joni.
All right. Vice Chair Hickman and I have discussed it. We're happy to serve if that's the pleasure of the board. So we have a motion on the floor and we have a second. Is there any further discussion by the board? Hearing none, all those in favor, please say aye.
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 Any opposition? All right, thank you, ladies. I'm happy to continue in the role. Item 3B is the approval of the June 11th, 2026 board meeting minutes, which we were sent. I think we were refreshed with that item. They are posted, but we were given those in an email.
Madam Chair, I'll make a motion to approve.
Thank you very much, Joni. Do I have a second?
I'll second the motion, Allison Chaffee.
Thank you, Allison. All right, we have a motion and a second on the minutes from June 11th. Any further discussion? All of those in favor for the minutes, please say aye.
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 Any opposition? Great. Motion passes. We'll move on to the draft bylaws. We don't have those, so I'm looking for some discussion from maybe Director Handy. Do you want to start us off on that item?
Yes, I can, Madam Chair. We have been working on a set of draft bylaws. We'd like to get a little bit more input from the board. I know Mr. Lambros just mentioned he had some ideas for bylaws for this board. I think it'd be helpful to get his input. As he explained, he's got a lot of experience in this kind of area. We've mentioned several times that we have a kind of rough draft together. We are trying to tailor the draft we have to suit this board a bit better than it does more generic boards. So our thought is we get a draft out to the board members much earlier before the next meeting, so then we can have a more substantive discussion about proposed bylaws at that meeting. But since we didn't send you anything out this meeting, you don't have much to go with today.
Thank you very much. Chris G., you have your hand up. Do you have comments on that?
Thank you. I'm just curious. I serve on the School District Bond Oversight Committee, and they do bylaws for some of their boards. So is the intent so that we have a better understanding for the board members to know what our role is, how motions are made, that type of thing? Is that what we're looking for? So
That's
maybe Peter,
yes.
go ahead.
It's mostly to just kind of re-explain what your roles and responsibilities are, give you kind of guidance so we don't have to necessarily pitch questions to the DAG about whether or not you can interject at this time or how a motion needs to be made, those kinds of things.
Okay.
It also gives an ability for, like, if people are expecting an absence, it kind of says, we can let the chair know so that we know to plan to determine whether there's a quorum a little bit better in advance. We have 7 members today. We knew who wasn't going to be here because we have a pretty active responsive board, but it can happen sometimes, right, where board members become disengaged or uninvolved, and it helps the chair and the other board members to kind of understand where there might be some deficiencies, or if somebody, thought they were off of the board for whatever reason and thinks they don't need to attend meetings, to help notify them that, by the way, you're still on the board, or vice versa on some occasions.
Right. So yeah, and to make sure that you can do a quorum, because it's a waste of staff's time as well as the board's time if you don't have that. So, okay, and do we have an absenteeism, any language in NRS? I don't think I saw anything. So that could be, I would say no more than 3, and then you should be removed or something along those lines. If you don't give notice, like 5 days ahead of a board meeting. Now, understanding an emergency is going to happen. So as you're looking at drafting up some language, maybe consider something along those lines.
I think that's a very good idea. I think what we're also looking at doing is working with the NAPD to see if there's some kind of best practices in oversight works from board-driven indigent defense systems, so that we have their input as well. Certainly, they can be a work in progress. And yeah, as to whether there should be like an absenteeism policy, as to what that should be, I think the board should determine. It might make sense to. Sorry, my video's been.
I know, it just went away.
Yeah, I'm glad you can still hear me. I'll keep going then. I think the idea, right, might be then to notify the appointing authority, whoever might be appropriate person. I don't know, because this is a board where many people are appointed from various different branches of government, different appointing authorities. I don't know how that affects how somebody could be removed from the board potentially for absenteeism. I would need to find out a little bit how that works in the meantime. But
I think it's worthwhile to engage in that. I think we should have a conflict of interest clause of some sort as well. And then perhaps a reporting back to whoever we are appointed to at least so that there's some communication back and forth. If it's a local government, somebody should be briefing them publicly on what has up, what's going on up to date, so to speak. So as you kind of play around with some language, I would make those suggestions. Thank you, Madam Chair.
Thank you. Joni, did I hear you had comments?
Yes, I do. Just a quick one, Madam Chair. My recommendation is that you appoint a very small group of members to work on a set of draft bylaws that could come back to the board for discussion and approval. I would volunteer to be on that board, and I think that John Lambros and Chris G should be voluntold.
And I look to our DAG to see if I don't think it's a formal subcommittee, but maybe a working group with under Director
It is
Handy.
just a working group. That's right.
If Joni's on it, I'm happy to be on it.
Great.
I just voluntold you.
I know it. I like it. I like that term.
Do we want that to be in the form of a motion, or Peter, do you have enough direction?
This is Senior DAG Todd Weiss.
Hi, Todd.
I don't think we can take a motion on it because it's not really
it's not
agendized that way.
Yeah,
I mean,
and I think the chair has the right to make appointments on a working group like this.
Great. So those that are interested, please contact Director Handy. We can put it on a future agenda if we want to make it formal. Otherwise, we'll have that working group get started. Does that sound like a good plan?
The working group, as long as it's less than a quorum, there's no requirement that it be an official working group. But,
Okay.
Please be careful that if anyone outside that working group talks to any other members, we have a walking quorum problem. So
what do we want? 4?
So I think, Madam Chair, if it's just Joni and Chris that are the board members involved, it shouldn't be a problem that will run into quorum issue. So long as they're not telling the rest of the board members that we're talking about. I think me and Homa can work with them and Mr. Lambros directly. We can send you the draft of what we have as a starting point, and then you can provide all the input you'd like. We're happy to kick that off, set meetings, get that finished before the next board meeting.
Well, I'm sorry to speak up here, but Joni just voluntold me, and I'm happy to help out. And I can't wait to work with you again, Joni. I would suggest that the board include, and I never warned him that I was going to say this, but I think the board should include Judge Fairman in that job, as well as former Chief Justice Maupin. I think that they could be very helpful. Judge Fairman as a former contract lawyer, district attorney, public defender, judge, and Chief Justice Maupin as the person that got this whole ball rolling in 2007.
Great.
Judge Fairman, I'd be happy to help any way I can.
Oh my God.
Me too.
First time I ever voluntold a couple of judges.
Thank you, Mr. Lambros. All right, Peter, I think you have good direction. I think we can hear as a board the plan going forward. So I think that's great.
Madam Chair, can we?
Yeah, go ahead, Mr. Blakey.
Be on that committee? Who's going to be on that committee?
We've got.
Well, it's not a committee. It's a working group.
I need to be very, very clear about that. This is not a committee because we're not voting to create an official group.
Right.
Because we can't. So yeah, this is just a less than quorum group who's talking about doing something, amongst themselves, which they're allowed to do. But again, please be very cautious about bringing more than a quorum of people, of members into that
members of the board
discussion, because then we'll have a problem. So
yeah, so my current list, if I can jump in, is
please, thank you.
Is Judge Fairman, Joni Easley, John Lambros, who's not a member of the board, Chris G, for right now, and potentially Justice Maupin if he's interested in being involved. I think last time he's a member, so
oh, he's here. He's
First of all, let the record reflect that I'm here, neither here nor there, and I would be happy to serve on the working group.
Thank you.
Madam Chair, I have one other question. Too many people were talking, I couldn't understand it. Was there one person that wants to be on the working group that's not on the board?
Yes, sir. We have Mr. John Lambros that was interested.
And should we restrict the working group to current board members? Or what's the advantage to having that member or that person on the working group?
There's, but well,
Go,
is there
Because
any
they're subject
prohibition
matter
against it?
experts.
Is there anything prohibiting using outside consultants?
I wouldn't think so because it's a very informal working group. It's not a subset of the board. So,
That's
if
what I
it's,
think.
yeah, if that's okay, Mr. Weiss, I
Yeah,
would,
no, Senior Director Todd Weiss for the record. Absolutely not. There's no requirement or there's no prohibition on outside folks contributing to members in a work group. In fact, even when subcommittees are created, which this is not, again, just to be clear, it's pretty common that they include some subject matter experts who are not board members.
Thank you for that. And then I have one other question for Mr. Handy. Is that too many people for your working group? Or is that the ideal number of people needed?
I think it's a good mix of people. I think that if we can get to a productive start that way. Again, bylaws, they shouldn't be too rigorous. It's just a kind of, we can get a lot of different ideas, probably distilled down the most fundamental, parts of it, and then it'd be something that we could present to the board for a future meeting for full board discussion. It wouldn't be something that this working group would be able to kind of finish on their own, certainly, right? So this would just be kind of getting the group together, developing how a draft of those bylaws would look, and then presenting to the board for their consideration, their input, and potential adoption whenever it's ready for that stage.
Thank you for that. Madam Chair, that concludes my questions.
thank you, Mr. Blakey. All right. We don't need a motion on that. We have good understanding who's going to be on it. I'm going to move us along, and part of the reason is I have a 3 o'clock hard stop, and I don't have my vice chair here, so I'm gonna snap us through this meeting, and if I need to pop off, I might turn it over to one of my fellow board members if Mr. Weiss will let me. Let's go on to item number 4, the Department of Indigent Defense updates. These are for discussion, and we have the director and then the 2 deputy directors. So I'll let you jump right in, Mr. Handy.
Thank you, Madam Chair. I'll kind of start with what was briefly mentioned in the opening public comment. Mr. Coates, the state public defender, provided a resignation. His last day with the in that office will be July 24th of 2026. We, of course, wish him well in his future endeavors and thank him for his service in the role. We're already working with some local partners to provide continuity of services and coverage in Humboldt County and White Pine County. We've been working with these folks anyway since they've been contractors at the State Public Defender's Office. We're looking at providing potentially a more expansive role where they're also going to be providing some staff support, some training and oversight for the new attorneys, or relatively new attorneys that are in those offices, and make sure that there continued to be there's continued support for them as they continue to learn and grow in the system, so they can kind of maximize their potential and not see it as a vacuum of leadership or supervision in the office. We really want to make sure that they're supported, that they feel supported, and that there's that they have a sufficient coverage capability so that their workloads don't become extreme, especially given how new they are to criminal defense in rural Nevada. We're also going to be working with the NAPD to conduct probably a national search for Mr. Coates' replacement. As Mr. Lambros kind of led to kind of indicated in the beginning, these positions are hard to fill for a variety of reasons. Certainly, we want to find the most experienced person with the most capabilities we can. NAPD has a lot of experience in this area and have a nationwide reach. So we're hoping to perform a nationwide search. Obviously, somebody local to rural Nevada who has a lot of experience in this area would be a kind of preferred candidate, but it turns out those are difficult and few and far between to find. We'll be working with the team to make sure there's a smooth transition. We're trying to, make sure that the office feels supported, that they feel like they can go about their normal business without any interruption or with minimal interruption. Hoping to work with the courts to the extent we need to make sure that they don't feel any interruption in service, and ultimately to make sure the clients are without any interruption in services as well. We think we can minimize client interruptions in service a great deal. It shouldn't be too complicated or onerous to continue services to clients just with Mr. Coates' departure. If anything changes, of course, we'll be reaching out to whoever we need to make sure that those services are provided on an emergent or urgent basis.
Thank you. Do you have anything else?
Yeah, there's a couple items. The annual report has been sent to the required persons. We're going to have copies printed and delivered as we've done in the past to make sure we get print copies out there. If anybody had any questions or comments on the report, since between seeing kind of the draft version and the final version, it looked very different, hopefully similar to those of you who've seen prior reports. We really were trying to return to that model. We have a lot of proposals for the legislature that I'm going to kind of now pivot into. Included in there. Again, the big ones are the same ones mentioned at the last meeting: pay parity, the alternate public defender's office, and the post-conviction solicitor's office. I think it's an important kind of role for the department to pick up, one where we don't currently have a role in, except to kind of process payments. And it's, as Justice Maupin mentioned at the last meeting, highly specialized, highly technical area of law. It makes sense to have some institution that's actually creating longevity training that's particularized to that area of practice, and to have some oversight in how that practice is performed. Currently, it's managed by all the district court judges who are appointing whomever they see fit in their jurisdictions to handle these cases, which can result in a lot of variance among the quality of work that's being done for clients. Hopefully that kind of a system would both consolidate that into a state agency, create that longevity, that institutional knowledge, and provide better services overall for persons at that point who've been convicted of crimes in Nevada. We're also looking at contemplating other kind of more expansion, looking at increasing staff in this office. As you probably noticed in the annual report, we're processing more things than we've ever done before. We're paying counties back more than we've ever paid them before. There's a lot more. Before I took on this role, we knew there was some administrative work. Since we started taking on some of the functions that the courts used to perform, like reviewing billing from attorneys, experts, investigators, that's grown drastically, and we haven't quite caught up yet with the level of growth that we've needed to. So that's going to be part of our other requests in the next budget cycle to the legislature. Speaking of the legislature, we do have a presentation we're going to be giving in front of Interim Judiciary Committee next week. I think it's on Tuesday. If any of you have the time and are interested, please tune in. We'll be giving it's usually a brief presentation to Interim Judiciary. We've always found them to be good partners in the past. They've always been very interested in what we're doing, what our ideas are, and they've taken some of those on themselves in the past. So we're hoping to work cooperatively with them. Hopefully the presentation they find informative and useful. I think the only other thing I have is to mention a couple of things that Brenda and Homer are going to talk about. One is our partnership with the United States U.S. Digital Response. We have a lot of processes in-house that I don't think we understood, like how many there were or how complicated they are. We are looking at ways to make some of the things that we do, like processing bills, more efficient. USDR kind of came in as a consultant. They really identified our core processes and then kind of manufacture like a map of how those actually play out, and the systems we're using to kind of try and implement our processes. And they found a lot of ways to make these things more efficient. So hopefully we can keep working with them in the future. That's, again, been at no cost to the department. They've been fantastic partners. They're volunteers, most of them former federal employees who have been really phenomenal to work with. They have excellent ideas, and they should be providing us with better solutions than we've contemplated even in the past. And Homa might have some more information about that during her report. As for training, I just wanted to briefly mention, we're probably getting into more depth later on as we talk about the monitor's report. We've allocated about $250,000 from those Davis funds that were provided to the department for compliance during the special session to a new training program for new attorneys. We're looking at kind of doing a hybrid online recorded portion with a live in-person training. Brenda can give you a bit more of a definition, but we've kind of rough estimated that at about a $250,000 price tag. I just want it's something we're excited about. So something to keep on your radar for the next couple of months as we start building those programs. And I'm happy to turn it over to anybody who has any questions for me about those items in my report.
Chair Thomas. Yeah. Hi, Allison Jaffe.
Hi, please go ahead.
Thank you. I wanted to go back to the public defender hire. as I understand it, the department has the final say in the hiring. I just wonder if we're subject to any pressures.
No,
Like,
the
okay,
decision to hire the state public defender is at my sole discretion. I don't, other than this board's input and advice, there are no other pressures that would push me in any direction to select or not select any particular candidate.
great. And you'll let board members know if you need assistance in that, if you need board members to contact references or anything like that.
Yeah, absolutely. This is a process where I'd certainly be leaning on the board members' expertise in both indigent defense and rural practice. So absolutely, this isn't something I can do alone. This is why I plan on including the National Association for Public Defense to conduct that search on our behalf. And they've been great partners so far in our current endeavors, and they bring a breadth and depth of knowledge that we don't have here in the agency. And so with them and the board, I think we have a very good shot at finding a very well qualified candidate.
How long do you think the process will be approximately?
That I don't know. I imagine they can be pretty quick on getting a solicitation out there, but it could take a little more time to see, who applies, what the ultimate kind of timeline is. Certainly, we'll figure out what the interim looks like and see how long of a runway makes sense before we make any decisions there. But really, the goal is to make the best decision we can rather than making a hair trigger decision about, getting someone in that position urgently.
Great. Thank you so much. I think this will be a good process for us.
Great. Thank you, Ms. Jaffe. Any other board members with comments or questions?
Yes, Ms. Thomas, this is Gary Fairman.
Go ahead, Mr.
Peter,
Fairman.
what's the range on the pay package for the Nevada State Public Defender?
It's not high. I couldn't tell you off the top of my head. It's somewhere in the low to mid 100,000 range, depending on whether it's employer paid, entirely employer paid PERS contributions or employer paid. It's certainly not the highest, which again is part of the push to the legislature to increase salaries, at least to be in parity with similar organizations across the state.
And that's a good idea, what you're doing. Thank you.
Thank you. I appreciate that, Judge.
Thank you. We have been in discussions with the governor's office on that as well. All right.
Chairman Thomas, I'd like to just throw something out there. I'm sorry, I can't get my video working, but I'll
This
just
is Senior Deputy Attorney General Todd Weiss with the Nevada Attorney General's office. I'm calling about invoice number 201.
Hey, Todd, you're not on mute. Can you? Sorry.
Oh,
All right, go ahead, Mr. Lambros. You're
okay,
good.
yeah.
We're multitasking.
I think that something the board might want to consider is, and this is going to sound a little bit maybe outrageous, but viewing the public defender's office in the state public defender's office in perhaps a little different light. Right now, the state public defender's office has kind of, and I don't mean to use this word facetiously, but has kind of degraded to a point where they're not even capable of handling the caseload in White Pine County, let alone Humboldt County. Now, if you look at what their obligations are under Chapter 180, they're the go-to for a corrective action plan county. They're also the go-to for any appeal that a county doesn't want to do, any capital cases that a rural county doesn't want to do. And I think, and obviously they're not suited to do that as we speak. I'm thinking that given the current iteration of Chapter 180 and where DIDS is now and where this board could be going, the board might want to think about a Nevada State Public Defender's Office that is a little bit mirrors what the California Appellate Project does in California. My son is a county public defender in Los Angeles. The LA County Public Defender's Office do not do any direct appeals. And so I guess what I'm saying is we might want to view the Nevada State Public Defender's Office from a little bit more realistic lens. I just don't know, and I think Judge Fairman brought up a very good point. The amount of money that the Nevada State Public Defender is paid is just about as much as a student that is in the top 20% of their class at Boyd can make their first year out in private practice. Not to degrade, not to be critical of the student that's coming out of Boyd, but it's just
Mr.
unreal.
Lambros, I'm so sorry to interrupt. Are you a member of this board?
I'm sorry, I don't know who just asked me that,
This
but
is
no,
Senior Dag Todd Weiss.
oh, I'm not a member of the board, but this was just my interjection of public comment.
We have to, and I don't want
Sorry, Todd.
to.
I'll
Yeah,
dial us in as
I'm
well. Sorry.
sorry.
Uh,
I know I don't want to stop I'm sure this commentary is very helpful, but just to keep fairness for everybody, we got to keep
yep.
public comment during those designated periods.
Okay, there are people on this board that I think can contribute now, and I would hope that they would. And along the same lines that I've been talking about. And if, I think future legislation promulgated by DID is not only critical to the future of the board, but critical to complying with the Davis stipulation, which DIDS is a party to. Thank you. And I promise, Kate, I won't say another word.
Thanks, John. We appreciate it. All right. And we will have public comment on the end too, so feel free. Okay, so members of the board, comments, questions on 4A before we turn it over to Brenda to talk about training.
This is Chris. Can I just reconfirm with Peter? Last session, the law changed so that the executive director of DIDS can appoint the public defender. Is that correct?
That is correct, yes.
Okay. And so you're free to seek candidates so our limitations still have to deal with not only support, but financing is what I'm kind of hearing from people as far as housing, where do they live, that kind of thing as well as. So I think as you look at a package, and nothing against Mr. Coates, I think everybody was just overwhelmed in that, and trying to get an office up and running was not, it was crazy. Anyway, so you still have flexibility now that we did not have prior.
Yes, much more flexibility.
Okay.
The governor's office appointment, it changed in the last session. So yeah, a lot more flexibility.
Okay. All right. Thank you.
Great. Any other board members? And obviously we'll keep everybody posted on the pursuit of the executive director. We know it's an item of high interest. So, all right, let's move on. Brenda, do you want to take us through item 4B, your overview of where we are on training?
Thank you, Chair. Brenda Roberts for the record. So I'm going to start with the CLE updates that we have, and the trainings that we've done year to date are acceptable medical practices for blood draws and reviewing medical records and what really happened. We have 4 CLEs scheduled in the next 2 months. One is billing ethics by Professor Rappaport. That will be on July 16th, and all of these have been emailed to the board, except for the last one. We have appeals nuts and bolts by Attorney Michael Lasher. That will be on July 23rd. We have a juvenile competency CLE. That is a panel with Dr. Melissa Kayaseki, Attorney Michelle Rodriguez, Attorney Julie Kavanaugh-Bill, and Juvenile Probation Officer Heather Plager. That'll be on August 21st. That's the one that I have not yet sent the notification of. It's a little early for that. We also have some virtual trainings where we have commitments from the presenter and tentative dates. We're just looking to finalize those dates. The first is managing experts, and that's Chris McKee out of Colorado and Kate Hickman out of the Washoe Alternate PD's office. That is tentatively set for August 20th, though that could change. The other one is a 2-day DNA training, and that will be in conjunction with the Washoe Public Defender's Office and alternate public defender's offices. That is also Chris McKee and a co-presenter who we have a couple of options in trying to work out whether they'll be available. And the dates that we have tentatively scheduled for that are September 10th and 11th. The other thing that we have going on for CLEs is the new lawyer training program that Peter talked about. And I say new lawyers and new to criminal law. And also for experienced lawyers who might want a refresher in some of their skills. So I did a real high level outline of the last time. We are looking at quarterly in-person skills workshops lasting 1 to 2 days. They would be spread around the state. So 3 going at one time, 1 in Elko, 1 in the Reno area, and 1 in Las Vegas. I've spoken with at least 1 experienced criminal defense attorney and each of the regions who is supportive of the idea and will help bring in trainers and help us get things set up in each of those areas. And they'll be able to practice things that they've learned in the lectures, which I'll talk about in just a minute. So everything from arguing bail, speaking with difficult clients, arguing motions, plea negotiations, evidence exercises, admitting, excluding, examining and cross-examining witnesses, some legal writing, sentencing arguments. These are the kind of things that can really be helpful in person. And those will be practicing skills that will be addressed in lectures leading up to these quarterly in-person workshops. We can do the Zoom lectures because we need to accommodate non-standard court schedules, long physical distances between getting to places. So having in-person lectures is, I think, an impediment to participation. These classes will be recorded. They will be made available on demand as requested by our indigent defense providers, and it will be limited to defense attorneys. And some of the topics that we're looking at are everything from basic attorney responsibilities under the ABA criminal standards, ADKT 411, the key provisions of the Nevada Rules of Professional Conduct, Nevada Rules of Criminal Procedure, calendaring, conflict checks, just sort of basic things like that, talking about remote appearances, what you can and cannot do, understanding local rules, understanding local calendars, appearing for other attorneys. Let's see, other things we're talking about are Valdez Jimenez and bail hearings, client communications, misdemeanor specific practice, preliminary hearings, motion work, negotiating cases, competency, evidence issues, witness examination, docket and Zunza, timely trial, legal writing is one of them, appeals, working with investigators, working with experts, sentencing, probation revocation, and probation as part of sentencing, and then looking at having some sort of specialized trainings on like DUI and domestic violence. So these are just some of the topics that we are looking at and having in our lectures. The idea that we would cycle through these every 1 to 2 years, depending on how dense it ends up being and what we need it to be. And with the ability, of course, to tweak it as we go along and identify new or different needs.
Great. Thank you for that overview. Obviously, very intensive amounts of training that you're putting forward. Super helpful. Do any members of the board have comments or questions?
I have a comment.
Justice Maupin, please.
Because of my specific experience as a district court judge and a Supreme Court justice, I would really like to be involved in the writing part of the program if they're going to go there.
Thank you, Justice Maupin. I will absolutely reach out to you on that.
Excellent. Thank you. Any other board members, questions or comments on the training overview from Deputy Director Roberts? Thanks, Brenda. We're going to move on to the oversight update from HOMA. Deputy Director Sire, please take it away.
HOMA Sire for the record. YAR. Understanding that you're on a bit of a time crunch, please know that I'm going to hit some areas and then I can provide follow-up at a further meeting and then also in writing, so I know you have a packed agenda. First, I wanted to mention that we recently completed, I visited just last week with 10 jurists across Winnemucca, Wells, Eureka, Battle Mountain, Willie, and Elko. They were really fruitful conversations. I had Mr. Sheik with me for the meeting from Willie and Eureka, and then I had Mr. Lopez with me for the remainder. We were able to get very, very candid feedback that has absolutely fed into Deputy Roberts' training planning. Many of the judges initially say that the quality of the attorneys appearing before them is, generally without complaint on their part, but then when pressed about areas to grow in, they had absolute suggestions. For example, we had a suggestion out of Elko for some dedicated training on sex offense tiers because they were recognizing that attorneys were not necessarily adept at understanding it. So that's a big opportunity that we can now turn to the board for expertise about and trying to build a curriculum. And there's been discussions internally about what if certain videos or certain trainings are required before an attorney can take a certain category of case that maybe they've never had before, just to try to give that extra update. It's possible the law has changed since they last did that type of case. Another thing we talked to judges about was the examination of remote appearances. Some judges have indicated that it's happening, and so they would like to see training on how to effectively do so. We've discussed the 80/50 rules and those sorts of things, but for them, they were indicating that sometimes it's a reality. So good practice it is a reality. We did observe several areas of concern while we were out observing court. I've made several referrals to Deputy Director Roberts, and for some investigations are ongoing. We were able to obtain some hearing recordings, that sort of thing. We believe that these are coachable issues, and that we can address them readily and then be able to present the board with the solutions as well as what we were able to identify. I know Ms. Gorson mentioned in public comment, the desire to see underlying oversight reports. Those are public record, but we moved away from affirmatively posting them on the website because without context, somebody's Googling them and it's affecting, we talk to attorneys and sometimes their willingness to do this work if they feel that a snapshot about a particular day or particular phase, observations about that is, kind of presented without the other aspects. But certainly those have all been provided to the monitor. And I feel like, and obviously she's on, so she can address it herself, but I feel like the strength of the monitor's reporting comes in part from our line of communication with her as things happen. We provide our oversight updates. We provide information as it goes on. For example, in Eureka on Monday, we met with members of the county commission, as well as Judge Rowley and the clerk, because we learned that they had lapsed contract for coverage. So we were able to have educational discussion about not just going to a conflict list in order to obtain counsel, but having that real nearby coverage. And as a result of that, we were able to write a memo, submit it to the board, being also drafted a contract that would tide them over, and we're also helping them draft a request for proposal. So I think that I feel like from our meetings with counties and officials, everyone is busy but wants to be in compliance, and something that the department can do, especially in partnership with the National Association of Civil Defense, is provide those rubrics and those samples. We're also doing that in my county. I know Mr. Sheik really wanted me to mention we are still wrangling with the removal of 432 cases from the contracts for the 12 Nye County attorneys who has understood that it would be removed. But again, we were able to offer draft amendment language that could just be plug and play. We've been circulating that among the 12 attorneys, and they seem to have positive responses to it. So that's another moving target. In the annual report, we did identify what we called areas of opportunity. So for example, the statutory review section, we have judges and others telling sometimes attorneys aren't checking the statutes. So if we know what specifically are areas that we could focus on, one thing we see recurring is that attorneys state on the record that they're not aware of certain evaluations that they are supposed to be getting prior to sentencing on certain cases. And I'm seeing that from newer attorneys, and I'm also seeing that from really experienced attorneys. So that's an opportunity for, maybe a little training, or we're going to be releasing our newsletter soon, and that would be a chance to say, please remember that this is something you have to do. This is something the court orders. And speaking of which, we're also putting together a guide of local, not necessarily just local rules, but local patterns and practice. Some counties, the defense attorney drafts the guilty plea agreement, others they don't. And we're seeing some of the complaints we do get from clients from others are that things are being done last minute. That's not always counsel's or fault. And then as Director Handy mentioned, we're moving forward. I know it sounds like government speak, but we're moving forward with a lot of our data collection and data improvement things because we want to improve compliance. And we are tantalizingly close to something where someone will run their practice able to generate their records and then export them to the state in the form they have it, no more double entry, and then eliminating excuses for not being able to manage these items. And then, so we're really excited about that. And to the point of the State Public Defender's Office, using contractual means to stabilize the office and to also, I'm calling it a receivership. We have scopes of work that we're shopping around to have on the ground management, supervision, looking at cases, because even if we're searching Nevada or elsewhere for a state public defender, we need to have something that's, oh, and that's someone we want to step into. And for someone who cares about this kind of work, it wouldn't be fair to hand them something where we don't even know what might have been going on, except obviously through our oversight observations. So I wanted to make sure I pointed that out. And I see Mr. Sheik is on, and he had some points I believe he really wanted to share. So I'll turn it over to him, and then we can also check in briefly with our other oversight support, who are just so wonderful and so gracious and letting me tag along as well. Thank you.
Madam Chairman, this is David Sheik. I am not a member of the board. I am, however, a contract oversight attorney. And I assume that it's okay with the Attorney General that I speak. And I don't know how to say this other than this. White Pine County is a mess. They fired the only experienced qualified attorney on July 2nd. And then the head of the office resigned on July 7th, which leaves exactly one attorney who is not qualified to handle anything above a low B, and who is also making appearances in Humboldt County handling cases there. That is the situation in White Pine County. It is a wreck. We are trying to, the best we can, come up with a way to meet the needs of the clients, but I think this board has lost view of the fact that it's the client that is important here, not the rules and not the regulations, but how are these clients being represented? We have so many clients in White Pine County who are now receiving letters saying, "Oh, you're going to get a new attorney, but we don't know who it is." We have non-attorney staff making decisions as to which cases are going to be reassigned. It is not a good situation, and I think the board needed to be aware of that. If I'm too blunt in my statements, I apologize. Additionally, on the Nye County situation, last January, we were assured that Nye County would remove the 432B hearings from the contracts of our attorneys. They have not done so. We met with them in February before we added the additional attorney positions, and we were assured it would take place. Mr. Langford was hired as the coordinator. He assured me that that would be taken care of. It is not taken care of. The attorneys are still receiving 432B cases to the extent that they're spending almost as much time doing family law as they are criminal law. And that situation needs to be corrected. And it could be as simple as we tell the attorneys, do not accept any more 432B appointments. It's not your job. And again, I apologize if I've raised my ire, but I needed to say that. Thank you.
Thank you, Mr.
Madam
Sheik.
Chair, this is Joni in Tonopah. Do you want me to follow up on that?
You may. Just real quick, though, I know there was original question about whether Mr. Sheik is able to speak. We have consistently in these board meetings had our monitors come in and speak regularly. So unless Mr. Weiss pulls me over, I'm going to say that is an absolute appropriate use of him speaking under that item, especially called in by deputy.
I agree.
Thank you.
Yeah, this
But
is Senior
please,
DAG Todd Weiss. I have no issue with that.
thank you. Go ahead, Joni, if you have more to say.
No, that was it. I
Okay.
just wondered if you want me to, and if it's appropriate, I can follow up on that as soon as this call is over.
Thank you.
And if I could leave, Madam Chair, if that's all right.
Please, go ahead, Peter.
So I just wanted to let you know that we've already sent some language that should correct that issue immediately to Nye County and the contractors in Nye County. So they have an easy opportunity to make the fix in the short time that we have before Davis compliance is expected. So I think if Ms. Easley wants to follow up, I think that's fantastic to help with the county to understand how urgent and necessary this is. We certainly appreciate it. And I just want to note, thank you, Mr. Sheik. I think this is kind of what we hear from Mr. Sheik, and sometimes you don't. So I hope you can appreciate that, this is the kind of unfiltered feedback we usually get, and we certainly appreciate it. Hopefully you do too.
We appreciate his openness and always want the most transparent communication that we can get. So I have no issue with that. Please do not apologize. Any other board members, questions on the oversight? And I know, Homa, did you want just Mr. Sheik? Did we have someone else that you wanted to speak? I'm sorry.
I know with deference to the length of the meeting, we were planning to, in the August meeting, have each of our oversight folks discuss a little more depth each individual county. We want to know about it. We want to make sure you have that information.
Thank you. All right. And then just so everyone knows, I did check offline. I don't want to stop or shut down the communications. It's a good meeting. There's a lot of good information. So I want my fellow board members to start thinking about, because what I confirmed is that when I have to drop off, that any member can volunteer to orchestrate the meeting in my absence. And so I would ask that one of my board members think about, if we don't wrap by 3, who could step in and continue the meeting going from the point that I have to leave forward. And I apologize that I didn't nail that down in advance, but we're going to move on.
Madam Chair, if
Yeah,
I have an item on that.
Yeah.
Concerning the White Pine County issue, is it possible that maybe Mr. Handy's office can reach out to some of the other counties? I know we're all busy and I know we're all maybe short-staffed, but is it a possibility that he can reach out and see if someone can share their attorneys to go help White Pine County for a brief moment? I understand when you take a case, it can be months long, but just to help show good cause that we are doing everything we can to make sure White Pine does not fall down. Is that even plausible?
Yes, Peter Haney for the record. Yes, both plausible. We've already reached out to the contractor for the NSPD in White Pine County. There's a couple of them. We've spoken with both of them about the situation. They're on board with helping out. We're also reaching out to other attorneys who have contracts in Lincoln County, for example. While they can't take all the cases immediately, there's certainly good backup in the event that the current attorney that's there in the state public defender's office can only take so many cases. He's only qualified up to a certain level. There are a lot of cases in White Pine County. So even if we need to offload some of those cases, we're working on ways to offload those to other attorneys who work nearby, who are already familiar with the judges and the systems in that area.
Thank you.
Mm-hmm.
Okay, other board members that have questions or comments on item 4C, the oversight issue.
May I say something?
Maupin. Yes, Justice Maupin.
I am start over. I think that having someone like David Sheik come in here and be blunt is exactly what we need. And to be quite frank with you, this whole business was founded to deal with a dirty little secret that there was a systemic problem in the indigent defense area of practicing law. So I think that these comments and it should be made in the context of when you're discussing them, and also should be welcomed as constructive comments rather than reactionary comments.
Thank you. I agree. Any other board members?
Madam Chair, if I may, this is Homa Sayar, while folks are maybe gathering their thoughts. As Executive Director Handy said, we do get very, very frank feedback from our oversight attorneys, and they're real treasures that way. I hope that the board doesn't interpret sort of our calm and sort of measured statements as not, being just as concerned, just as, worried about what is happening and what we need to do. We had the monitor's report indicated things that we had shared about our concerns, for example, with the state public defender's office, and we had been preparing contingency planning for some time in light of that. So I just wanted to echo that and then say that certainly if if the board would like those sorts of updates as well to be heard or to be documented, we're happy to do so. But as I said before, we definitely want to also try to bring solutions. And then also there are days where we talk to our oversight attorneys multiple times a day. And I apologize if my audio is a little weak, so I'll stop there. And I believe Professor Hanan had gone on to her camera. I wasn't sure if she wanted to offer some comments.
All right, thank you, Homa. Yeah, your audio's a little bit glitchy, but go ahead. Sorry.
Chair Thomas.
Yes, go ahead, Ms. Jaffe.
I'd be happy to offer to chair the meeting in your absence.
Thank
looks
you.
It looks like we're going to get through our important information from Professor Hanan. So I feel comfortable doing that. And of course, there's lots of help.
Thank you so much, Ms. Jaffe. I appreciate that.
Sure.
Okay. Yes, and great comments, Homa, on how we interpret the board's, or rather the staff's demurrer. We are all quite concerned. I know. So thank you, Mr. Sheik, for elevating that. If we're comfortable as a board, do we want to move on to the Davis litigation updates? And that's item 5A. So Peter, if you are good. And Ellison, do you want to take over now?
Sure.
Okay, folks, I'm gonna have board member Jaffe take over for me. I'm gonna listen in. This is lovely, and I'll eat a little lunch. And then that way, when I dip off, it's not disruptive. So thank you. Go ahead, Allison.
Sure. So yeah, let's move on to our next item with Professor Hanan.
Sure. I know I'm the listed item under 5A as the executive director. I'll just mention again, like I seem to do it every time we get a monitor's report, and say, of course, the monitor's report is our guide for how we handle business here until the next report comes out. I think we've had a lot of discussions in the past about how things in the report keep developing, and so we keep trying to hone in on what the next problem is and keep trying to improve how things are running here. And we really appreciate Professor Hanan's insight into how those improvements can be made and what the best practices are that we can try to incorporate. And I'm happy, since she's here on the call, if I could, Madam Chair, defer to her to give an overview of her latest report.
Yes, thank you, Peter. That'd be great. Professor Hanan, you're up.
Thank you. Thank you, Peter. Thank you, everyone, for being here. I'm not going to, there's different parts to this report, so I'll just highlight a couple parts which have to do with what we're talking about today. And of course, I'm available to answer any questions. I did lead in this report with concerns about the Nevada State Public Defender. Now it's out of date. A lot has happened since then. However, as the oversight attorney, as David mentioned, there's a lot of concerns, and I'm really very worried about the clients in White Pine County, and especially the incarcerated ones, delays in their cases. Some of them have had multiple attorneys at this point, which violates the judgment's requirement for vertical representation. And so I'm eager to hear how the department puts a patch on this, at least until the state public defender can be built up. If the state public defender can't be built up into something envisioned in the statutory scheme, another point I make is that the statutory scheme has to change, because really the department's and the board's only power when it comes to a county which is not providing effective assistance of counsel or complying with the judgment's requirements is to bring in the state public defender as part of a corrective action plan. If we don't have a robust and excellent state public defender, that's impossible. So to me, this issue of building the state public defender is front and center, and in the short term, making sure that every single client in White Pine County who lost their attorney in the last couple weeks has an attorney, a qualified attorney, and hopefully a forever attorney, if you will, rather than just somebody on a temporary basis. It seems very important to me. Another issue that came up, really it was raised, I received some emails regarding the contracts in Douglas County, and we talked about that at the last meeting. And it raised an issue which I think is a bit thorny. I did have an opportunity, as I write in the report, to meet with the attorneys for both sides about the contracts and what constitutes a flat fee contract and what constitutes a contract which has financial disincentives, which are prohibited by the judgment as well. Meaning, of course, that there's a real financial disincentive to doing more work on the case and an incentive to doing less work. We don't have all those issues analyzed yet. You can read what I've said about that. Definitely, it seems that just simply saying, well, if you have an extraordinary expense, come back to us and let us know, and you might be able to get additional compensation, doesn't turn a lump sum contract into something that's compliant with the judgment. But what I think I'm going to do for my next report is just review the contracts as they are for fiscal year 2027 in the Davis counties and do the best analysis that I can on what the financial incentives and disincentives are, and then leave it to the parties to discuss whether it's compliant or not. It's just a little bit of a thorny issue because the judgment actually says that pay should be on an hourly basis and there shouldn't be a flat fee contract. However, to attract attorneys to rural counties for, say, a full-time contract, they're usually compensated giving quarterly payments for a compensation amount that is for the year, with a clause in there for extraordinary expenses. So understanding what the judgment really requires and what the parties' intent were in the judgment is just going to take a little bit more time. But I tried to give a preview of that in a few pages of this report. And then finally, I just want to note that this relates really to the problems in some of these counties. And one is Nye County. Mr. Sheik just talked about the White Pine concern, but another concern that he's raised over and over again is that in Nye County, we're not seeing reporting significant hours spent on casework. And I just ask that you turn your attention to that part of the report because it's confusing to me whether this is a problem of attorneys not reporting enough or not doing the work that they need to do. And if it's the latter, then that's an issue for training and oversight. And it also may be an issue of where the financial incentives are, given that we have a lack of comprehensive or even sometimes any reporting of private workload hours. But those issues in Nye County are, I think, close to as emergent and serious as what's happening in White Pine County. If the numbers of hours and the work spent as it's reported is accurate, given that they now have 11, 12 attorneys and they're at workload, if they're not working those cases and they're not in the county doing that, then that's a real problem. That's a problem for oversight that this board needs to look into. If on the other hand, it's a problem of not reporting the hours, then, that's a different problem. So I'm happy to answer any questions if there are any. And also, just hear any feedback or anything you think that you'd like to see more of in my reporting or include if there's anything that you think is either not fair or not complete in it as well. So thank you, everyone.
Questions?
Yes.
This is, go ahead, Justice Swafford.
What the professor has identified are two co-equal and inextricably related problems. One, the actual doing of the work, and second, the documenting of the work for billing purposes. Billing should be by the hour, but it also should be a contemporaneous record so that you don't lose the elements of your representation in the billing. So I think that those are the actual doing of the time and the charging for it are so related that we need to have some updated CLE on it. And law firms all the time go through this problem, private law firms. So if that happens, then it certainly is going to happen here.
Thank you, Justice Maupin. Judge Fairman, were you next?
Yeah, thank you very much. Just a few comments, sort of along the lines of Mr. Sheik and Professor Hanan concerning White Pine County. I agree from everything that I've read, and I know living here that our representation there at this point in time is really in chaos, and I'm sure it appears that way to the clients who are being represented. Having seen multiple attorneys, and they've seen multiple attorneys over a number of years in White Pine County because, as we all know, we've had great difficulty in staffing that office. It's been a tremendous challenge, and one that hopefully we'll be able to overcome to keep the public defender there. But if not, and Professor Hanan alluded to it a little bit, we really need to focus maybe on some statutory changes. I spoke about this before. One is money. I think that you're going to have to offer a lot more money than we're offering for the state public defender and for those deputies. As I've said before, rural Nevada is not for everyone, particularly remote rural Nevada and anywhere in remote America. So you have to have some enticement to have persons of excellent quality in their services consider relocating. That's a big jump. It's a huge jump because you need those persons to be on site and not to be commuters. And so that's part of the commitment is that there's enough of a carrot out there to have those quality counsel. You say, I'm gonna take a leap. I'm going to move to that community. I'm going to be there, absent my own personal time away, and that's going to be my home and to provide services. And I think that's what you truly need. Prior to the Nevada State Public Defender coming on board most recently, as all of you know, I'm sort of preaching to the choir here. There were three very competent contract attorneys that are there. One of them is still there, and Ms. Eberhardy providing work. And from the judge's judicial standpoint, the representation was excellent, and they were basically part of that community. Fortunately, 2 out of 3 of them lived there, and one was there all the time, as it turned out. And so they were there. They had constant access to clients. Clients could see them personally, quite frequently. There was office staff there. Many clients are not in jail. They've been OR'd, or have lower bails. They can at least go in and see office staff, which is somewhat comforting, even if they can't see the attorney. They know that they have a local contact, and so salaries has to be a big priority for us going forward with the legislature to the extent that we could get more money to acquire attorneys to take that leap. I think that's critical. And without that, I think we're going to continue to face these challenges that we're facing now. And so hopefully we can overcome that and also allow the public defender, whoever we get out there, to have some private practice. Given the number of hours that they have, so long as it doesn't interfere, we could be creative to allow them to do some private practice. I think that's an approach we need to at least look at. Thank you.
Thank you, Judge Fairman. I'd like to echo what Judge Fairman and Justice Maupin have been talking about. And I know that the legislature is getting ready at this point to tackle these issues. And I think if we can set an example with higher pay, at least first for the public defender, and get some incentives to having some of the lawyers move to the counties. All of that is about money, and I really believe that the performance, there are believers among lawyers, but they have to be paid, and this is not popular work. So we really need to incentivize our folks. And so I think if we can get some action going with the public defender and the legislature, I think that would be excellent. And I think if we do be creative and really push to see if we can get some of our rural attorneys to live in the county, would be something really necessary. I think we're talking about money, we're talking about performance and standards for performance and caseload standards. Those to me are the really important issues that we need to get handled here.
Chair
Any
Johnson?
other?
Yeah,
Yes.
this is Chris. If I don't, I'm sorry, Justice Maupin, you want to go ahead?
Yeah, just briefly, the the cost analysis this is kind of counterintuitive because they think, well, because you're practicing out in a small town, it isn't as rigorous. It's no different than every case is none of the cases are any different than they are in the big counties. So my sense is that if you pay higher salaries up front, you will save a lot of money down the road. If for nothing else, the appellate processes afterwards are going to be, they'll be more expensive if you are having poor representation at the trial level, and so the case will cost infinitely more if you don't have it done competently the first time.
Thank you, Justice Maupin. Joni?
Yes.
Did you have comments?
I think it was Chris.
No, I did not
sorry,
raise my
Chris.
hand.
Sorry, it was Chris.
All right.
Thanks, Peter. Sorry, Joni. I just wanted to say we've beaten back and forth over the last few years. How do we incentivize? And I know we still need more funding from the legislature. That's for salaries. But I really still think we should be looking at, and Peter remind me, because maybe it was before when Marcy was there, we were talking about loan payoffs of loans for schools, housing components, different mileage structure. I think we need some, and maybe we just ask people, what would lure you here? If we can find folks that have some kind of long time commitment or connection to family back in the day, maybe we woo them in. I mean, they're just might, and I know that that's frustrating, but I think we need to come up with a plan for asking next session so that, because it's not unique to bids. It's unique to any kind of rural recruitment. And I just think we have to be, the state needs to be sensitive to that. And I can say that as a former legislator. There are ways to finance incentives for people. And what's different for one might be childcare. What might be for another one, you know what I mean? So I think we need to be a little bit more intuitive in who we recruit, and then we ask what would it take besides, in addition to salary, what would be the right salary, but what else would it take to keep you here?
I think those are excellent points.
If I could chime in,
Justice Maupin.
Chris G is right all the way on this.
Thank you. Peter?
You've never said that about me before. Thank you.
I've always thought it, though.
I think I just add, right, yes, we are exploring a few of those things. We've tried the loan repayment assistance. That didn't get any traction the last time we pitched it. We have got a lot of traction with housing down payment assistance. We know that it's hard to get out to those rural and frontier areas. There aren't a lot of housing opportunities to begin with, and they can be unexpectedly cost prohibitive than you might expect rural places to be in a lot of cases, especially for people new to the area. We're also contemplating like scholarship opportunities. It's not uncommon for people to come out of these rural and frontier places, go to college, go to law school, and then try to come back. And we really should be incentivizing them to do that through scholarship opportunities, through fellowship opportunities, try to get them to return to where they're already coming from, where they want to go back to. We heard the story of one person who came from rural Nevada and went to Ole Miss because it was cheaper to go there to law school than it was to go to Boyd. And that doesn't make sense to us, right? They should be staying and then being able to go back to where they grew up to then start practicing. So we're looking at other opportunities, other avenues for, long-term bringing people back into rural Nevada and getting new people into rural Nevada. We're trying, it's a lot to balance while we're doing the short term, the midterm, and the long term, but it's certainly nothing that's escaping things we're contemplating. And we're trying to we push around as many things as we can with as many people as we can. But certainly, if you have any ideas, please let us know. If you have any idea about who we should be talking to kind of generate traction for some of those ideas, please let us know, especially with the legislative session coming up so soon.
Thank you, Peter. And Madam Chair, Chris, just follow up. I wonder, I know that Northern Nevada Building Trades have like their own land development program, and they'll go do affordable housing. And I wonder if maybe that could be some kind of a partnership for marriage, because I want people to live in a house that's comfortable, not just a hotel or motel, right? I mean, that's just, if you want to build some roots, you want something of quality. So maybe there might be some kind of consortium there. I know that they build several houses in Reno, so maybe that might be something to reach out to. I think it's Mr. Bennett is his name, is the president.
Thank you, Chris. Peter, would you mind in your emailing to us all of the different ideas that we've come up today and what you have found effective?
Sure. Absolutely.
And yeah, and maybe we can all take part, especially in our local counties. We might be able to say, yeah, I'll contact so and so, just like Joni did a little bit ago.
Yeah, I mean, a county should know all their BLM land. There could be a partnership that's done where the BLM is done, the housing's placed on a RMPP lease. That cuts down costs, and then you hire a construction crew and or union crew to come in and design and build. I mean, so there might be some other ways to look at land that local governments could help with.
And we could charge the counties less money and have the states take over. And the counties would be happy to help us in
Exactly.
other ways.
Yeah, it's a different monetary switch that helps them with their budgeting, I would think.
Oh, yeah.
And Joni had her hand raised.
Joni, back
yes,
to you.
This time I actually did. Yeah. And I have a little more pragmatic view of what's happening with these public defenders. First of all, places like Ely and Tonopah and Winnemucca, I've said this 100 times, we aspire to be rural, but we're not rural. Right now, our federal designation is still the frontier. We are part of what's left of the American Western frontier. And the cold, hard reality is that these people don't want to live here. It doesn't matter if you find them houses or that you get them a little extra travel money or contract money. They don't want to be here. They want to live in Las Vegas where all of their social needs are being met and just travel to, if you can even get them to do that, to where the work is. And that is an unfortunate reality, and I don't know how you fix that.
Any other comments or questions for Professor Hanan?
This is Chris. The report was well done. Thank you for pointing out our flaws. I do think with the resignation, we can go forward and Peter can work on really trying to get the right staffing to address the needs, because it was a bothersome report in my mind.
It was an outstanding report, and it made a lot of us pull off our rose-tinted glasses. It was a terrific report.
Yeah.
Thank you,
Professor Anand. Could you also talk about the remote appearance and a little bit of those issues? First of all, I mean, I think for recruiting lawyers, the best thing is for us to be allowed to have remote appearances, but for the client, that's not the best. Do you have any ideas of what we can do kind of in between?
So I'll start. Yes, thank you. I want to start with saying that the judgment, which was written before the COVID crisis, has language in it that I think it's around bail hearings, that there should be no remote appearances or remote hearings. And then we had COVID, and many things have changed in litigation since then. In some areas, in some states, more happens remotely than here. And we also have ADKT, I'm forgetting the number right now, which governs in general remote appearances. So in this landscape, what I've tried to do in the reports is to talk about the issues with remote appearances in terms of how they can negatively impact assistance of counsel. One way, and the main way, is when it results in a lack of required communication or necessary communication between attorneys and their clients, either before the hearing or especially I worry during the hearing when the defendant is in person or he's remote from the prison or jail and the attorney is in his office and not in the courtroom and also not with the client and may not have a way to talk with his client confidentially. Perhaps there's some kind of arrangement made. Oh, well, if you need to talk to your client, we'll allow you to go and call on the phone or something like that. But, for those of us who have represented folks charged with crimes, we know that in the middle of a hearing, it's doubtful that they're going to be willing to say, wait, can we stop so I can talk to my attorney? Those conversations happen when the attorney and client are together and the attorney notices that the client is uncomfortable or nervous or wants to whisper in their ear something and get clear on what's happening. So I started to look at these virtual appearances more in terms of, what's the quality of representation? And I think some of the oversight attorneys have done a good job documenting in their court observations who's in court and who's not, the defendant or the attorney, and what the impact is. So I wish there was a simple answer, but I think there needs to be some work done to set standards that are clear for attorneys. So the attorneys know what is really expected of them in terms of performance standards, which is, the job of this board with the help of the department to set those performance standards, incorporating what the Nevada Supreme Court has said about it and adding to it in terms of what's expected for criminal defense, for representation of the accused in indigent defense. So, I'd be happy to offer a bit more if it's helpful. And again, I started by saying we've strayed from the terms of the judgment a bit, which really contemplate all in person. However, perhaps there are other considerations. I don't know what the parties would say about that today.
Thank you. And are there any other questions for Professor Anand? I would really like to join in thanking you so much for this report, especially. It was on point and timely, and I think it caught our interest, right? And I think, all of us are searching for what we can do to really assist the rural client.
Thank you. I believe I saw that Justice Maupin had his hand raised.
Yeah, you raise a very important point. The COVID created separation by using Zoom and all that business from the client and the lawyer because it was necessary because of the exigencies of the international health crisis. The throwback from it is that it was more convenient, and people were talking about changing business models for law practices from brick and mortar facilities to practicing from home. This continues a disconnection, and if there is any association that needs connection, it's the one that is created between a lawyer and the lawyer's client. So the necessity to be in person with a client is a kind of a subjective thing. But subjective or not, we know that disconnection doesn't work, and connection between the lawyer and the client means better representation.
Thank you. Other questions or comments? Let's, can we also look at, let me see. Just making sure that Professor Anon, you have, you can cover the issues. I think we need to talk about the counties with e-filing systems. And is there anything we can do to assist that or notify the state how important it is, or actually the counties, because I think they're in charge of e-filing, but I know it's very helpful to lawyers, criminal defense lawyers especially, to be able to e-file, because I think we're having a dearth of pre-trial filings by counsel.
And I can jump in, Madam Chair, and offer a little bit of insight about what we do when it comes to e-filing systems. So, for example, Carson recently has looked into onboarding a new e-filing system. They haven't had one historically. They've indicated in the past it's cost prohibitive. We actually drafted a brief memo to the board of city supervisors to let them know that we are in favor supporting e-filing systems for all the reasons that you might imagine, right? Public access, easier accessibility for attorneys to get copies of their documents and court records, access for clients potentially get a hold of their records if for some reason there's not continuity in their counsel. It's certainly going to be, I won't say that it's going to be a way that will necessarily cause attorneys to file more motions, but it might, if they see that as a barrier to it, it would remove that barrier. It may give them some more time in filing motions that are necessary that they might not otherwise have if they're looking to be able to file at something like 11:59 at night instead of trying to get somebody to the counter before close of business. Certainly, we have run into issues where attorneys are less likely to take cases on an appointed basis in counties that do not permit e-filing because of the additional costs and difficulty of getting wet signatures to those courts. So it has occurred where, in several cases where attorneys have indicated to us that it's such a burdensome way to try to practice without e-filing that they'd rather not work in those cases, even if they can otherwise, come up and meet with their clients. Because they can't access or view or have kind of instantaneous service or work with the court more easily than trying to deal with kind of the more arcane historical practice of, taking your ACO triplicate copy to the counter, getting them all filed, stamped, and walking away. So I think it would be very helpful if more counties adopted e-filing systems. Some are permitting some like limited e-filing, so filing by email or some other kind of substitute system without it being a fully robust like e-filing service like eFlex or some of the others you might be familiar with. We do, of course, encourage as much flexibility from the courts as they're willing to permit, and we certainly encourage any of the counties that haven't adopted full e-filing systems to do so. And we're happy to work with them to identify providers, explain kind of what other counties have experienced and what's been working best for our providers.
Thank you. I know I've had to do 11:59 filings. It can be helpful. Thank you, Peter. Is there anything else, Peter, that you think is important for you to discuss under Professor Hanon's all of the, make sure that we
I think
about.
chief items there were listed in the agenda, right? The guidelines for appearances and case coverage, which we'd already gone through. I think the reporting of private work continues to be an ongoing issue that we've had a lot of problems trying to resolve. Obviously, we can't track attorneys' private caseloads. We're looking at working with the board to either develop in the regulation process, or it might be through just the general contracting process with the counties or the application process to be on our list, that attorneys need to identify other public contracts that they have so we can track those. It's going to retention. There are several attorneys that have contracts in Washoe or Clark County with the county or cities. And then they're also trying to take cases by appointment in the rural counties. We want to make sure that they're not overloading themselves with too many cases. Obviously, they might see it as a good business opportunity to take on those contracts and other work, but we can't have them be taking an opportunity to the detriment of clients that they're supposed to be serving where we're overseeing them. So we want to be able to get a handle on at least the public-facing contracts. Of course, we'd like them to disclose all of their private workload. We don't need to know, obviously, the case names or their clients or all the things they must keep confidential pursuant to their ethical obligations, but the amount of time that they're investing or it doesn't have to be we really ask for just a quarterly report, right? We say every quarter, let us know, here's the form, let us know how many hours you spent on private caseload so we can better determine how much of a criminal indigent defense caseload you're suitable for being assigned to. And when we're not even getting good data for that, it becomes difficult to identify whether there are going to be performance problems based on their workload or whether they could be based on some other factors, like they need more assistance with training or supervision, or if it's obvious, right, that it might be they just clearly have too much of a private caseload to carry over. Certainly, as mentioned earlier, we would like attorneys who are settled in these rural and frontier counties to have the ability to practice privately. I think it's good for the communities to have additional attorneys there practicing privately. But for certainly those attorneys who have full-time contracts, it's really important for us to be aware of how much other time they are spending in their private practice so that it's not, again, not being detrimental to the clients, which is what we're really trying to discover.
May I say something else about that as well? The private workload reporting, some attorneys do it, many don't. It's required by the judgment and I believe by the regulations as well. But it interacts very closely with the question of financial disincentives in the contracts. Because if somebody's not reporting a lot of hours on their work under a full-time contract, and the oversight attorney is saying, I'm actually not seeing them in this courthouse very often, then the question is whether or not, and of course they're entitled to do private work and have private cases, but whether or not there's a disincentive to work on the cases that are paid under the lump sum contract of indigent defense and instead focus on the private clients. So it is really critical to know that. And I just also really appreciate, even though it's not in the judgment, specifically, or I should say directly, the department's efforts to get a handle on how much indigent defense work folks are doing if they're taking municipal court contracts in addition to the county ones that they know about, because knowing that total workload is essential to the judgment.
Thank you, Professor. I wonder, Peter, is there a way that that the department could develop a billing system, and so we could just have everybody counting their hours the same way, reporting the same way, and just have one very simple form? I know a lot of lawyers actually keep one on their desk while they're doing their work, so every 10 minutes gets reported.
Yeah, I remember time slips a long time ago. I don't miss those.
Right.
Yeah, that's part of the things that we've been working with the U.S. Digital Response is we know the attorneys, many of them are using their own case management system. They're in alongside using Legal Server for their appointed systems. So what we'd like to do is create a system where they can just export all of the data. It's anonymized, so they're not sending us the client information, right? But just tells us like total, here's the number of hours this attorney entered into their system for a given month or a given quarter. And then we can identify whether or not they're spending too much work on these cases, right? So it sounds like there are some kind of built systems out there. We wouldn't be going away from Legal Server because Legal Server provides a lot of other functionality, especially for those using it as a case management system, and it allows us to get a better handle on the particulars of what's happening day to day in a lot of attorneys' cases. But that's also a fine line to walk because they also, again, have to keep a lot of that information confidential. But this kind of imagined system and one that we haven't built out yet, but we're looking to, would then kind of be a clearinghouse for all that data so that an attorney, whether they're using Clio or whatever their system might be, could just kind of export a spreadsheet, import it into this program, and it would kind of spit out the data, what kind of time they spent it on. It would be anonymous, so we wouldn't know if it's a private workload or if there's a way maybe to break it out with some of those programs. Many of those programs have very robust reporting capabilities within them. So they might be able to generate reports that work specifically with this future software. And I think it does a couple of things. One, it makes it easier for the attorneys to continue their practice without having to double enter a lot of the same information, right? So we have situations where attorneys are entering it in their main case management system. They have staff or the attorneys themselves are entering it again in legal server to ensure they're either meeting reporting compliance or so that they can get paid by billing through us. We check all of their billing that comes to our department against legal server, so we do tend to get better reporting from them for their indigent defense time. But it would prevent them from having to do that extra work and take on potentially that extra cost. Hopefully, it would encourage better reporting with more frequency, more willingness to disclose the data. As for private reporting, like I think that would kind of, if it comes in a lump sum, we can still identify where that's at. Especially if we already have a handle of how many cases, right, we've given to those attorneys, or if they're working under a contract, we should be able to identify which portion of that is to those indigent cases. Again, it's nothing that exists now. I won't have details until we get more idea of where it goes, but that's kind of where we're looking at going, rather than trying to say, you must use legal server, which just has some functionality drawbacks. We have some concerns when we go to look at the workload again, right? That it might not be collecting accurate enough data for us to make good projections about how long the average type of case is going to take. There are issues with the system where if an attorney gets a good result and they change the charge in the case to whatever the sentence charge was, it changes the initial charge to the same thing. So we can't track whether attorneys are getting good results in the system. And we believe, and in many cases know that they are. And it's unfortunate that we can't see how good of a metric that is for their performance, right? So ideally, we could get a better system or a better method of tracking the data we really need to identify what case loads, case weights should be, and as well as tracking things like private time and time they're spending for experts, investigators, staff time, all these other things would be really helpful to know when we bring in, a data analyst to come in and make those kind of reviews in the future.
Great. Thank you so much. It's a lot of work in a lot of different areas.
Madam Chair, concerning the private work, I'd just like to make sure the board, we may need to be thinking about giving a more direct directive to staff to help the private work reporting, as the judgment states, to come into compliance. And I think it might be time, seeing how we're having issues in a few other places, to let everyone that works for us, per se, that's involved, know that, hey, we got to step up our game here, and we've got to get this together before it gets any worse. So I don't know if the board would, entertain something like that today, but maybe the staff could do a soft approach to let them know that, hey, the board has recognized that this is an issue, and there could be, stern action coming soon, per se.
We are in a item number 5. We are allowed to have possible action, and so if maybe we could get comment from go in that direction, and with Peter to see if you think that would assist you to get the our lawyers to take care of this a little bit better.
Sure, if I could jump in, like a couple of things. I think we could treat it the same way we've treated non-compliant reporting in the past. So what we've done in the past is kind of given the attorneys a heads up. Remember, it's the end of the compliance period. You need to get your reporting in. Okay, we're past the compliance period. You should have had your reporting in, but it certainly needs to be in now. And then if there's still no reporting, or de minimis reporting, then we can report it to various counties, right? County managers or county commissioners, whoever those contracting or supervising entities might be, to let them know that we're not receiving adequate reporting. Again, because we're kind of detached in a lot of ways from who hires and contracts with these attorneys, we don't have as kind of big a stick as might seem, like the board member mentioned. So I think it might make more sense, though, to kind of let the counties know that their attorneys might be underreporting or misreporting, and they could take appropriate action under their, the terms of their contracts, which do incorporate these reporting requirements. If that's something that's amenable to, we can certainly proceed like we have in the past with that.
Could we hear from some of the other board members? Are you comfortable with directing Peter to go through this process?
I am.
Okay. Joni is. I certainly am. Anybody else? Well, maybe I could just
This
ask.
is Chris. I am too.
Great. Thank you.
Yes, same.
This is a test to see if everybody's still awake.
Because I think somebody could make a motion at some point.
Gary Fairman, and I'm supportive as well.
Okay.
Well, I would like the record to reflect that I have once again agreed with Christian Chiliani.
All right. Peter, do you need a motion, or are you comfortable with the directive from the board?
I don't need a motion. I think that direct, well understood, well taken.
Right. Thank you so much.
And I guess I would just like to add, if you don't think you're making any progress, just give us a shout and we'll do something more direct.
Right. I think that's great, Mr. Blake.
Yeah, I appreciate that. And we will certainly keep that in mind.
Okay. All right. Any further on item number 5? Thank you. Let's move then to item number 6. The board and advice and recommendation under NRS 180-320-1H. And this is also for discussion and possible action.
And if I could briefly, Madam Chair, some of these items have become moot based on recent events. We just kind of keep this on as a running list, like we've indicated in the prior board meetings. If there are any that the chair or the board see fit to kind of skip for this meeting and table, I would. I'm happy to discuss any of the items at the board's pleasure. I think the most important ones kind of at this point, we actually talked about the list of counties, the filing systems a bit. I've generated a rough document of that, and I can send that to the board members if the entire board is interested. We're trying to refine it because it does vary somewhat from court to court, even within a jurisdiction. For example, some district courts allow some forms of email filing, while some justice courts in the same jurisdictions might not. But it's not a comprehensive list, but it can give you a good idea of where the counties currently stand. And we can talk about things like rural stakeholder meetings. Some of these have sort of been in the present atmosphere, sort of back burner kind of issues, things like rural stakeholder meetings with continuity, certainly things that we're not going to follow through with, but things that there are some more pressing issues currently. So again, if there are any items in item 6 that the chair or the board would like us to address, I'm happy to do so.
I know I jumped in under 4 and 5 to talk to Professor Anand about that. So I think we definitely covered that. Anything else for discussion on item 6?
I think on the remote appearance and council coverage, I think we need to start really having good discussions about how important it is for our attorneys to be in the courtroom and not on the computer. It as Judge Moppin said, it does do an injustice to our clients and
Amen.
us to meet the guidelines that they gave us. So I think that's hugely important. I think the days of remote appearance are of the past.
Especially in criminal work. I think you're right.
This is Chris. Absolutely. I echo it. I dealt with the school district who had a trustee who was moved to Nebraska, and it was like an act of God for me to get the district attorney to even investigate. So I think people have an obligation to representation, especially when you're an elected, let alone hired.
Thank you so much, Chris G.
Yeah, thank you. And we can certainly, I don't know if what I might do, if that's all right with the chair and the board, is circle with our DAG and consider whether this might be an idea for promulgating as a regulation, or whether it might just be general guidance from the board to the department to develop guidelines to then pass on to the attorneys. I think either is probably an acceptable way to go, but I just want to let you know that that's kind of, I think, the plan for now, if that's acceptable to you all.
Again, does anybody want to make any comment, and are you is that acceptable to the board members?
I accept that procedure that he wants to do, and if he thinks he's not accomplishing anything, let us know.
Kate Thomas is in with a thumbs up for us. She's still there. All right. Thank you so much. Thank you, Peter.
Mhm.
Item number 7, workload compliance update. Peter, that's up on you.
Yes, and I'll be brief again. There isn't a substantial change from the last board meeting. I will note a couple of things. I've been in communication with Brian Filter. He's a director in Douglas County, particularly about the contracts in that county and about the monitor's most recent report. He's been working with me to kind of better understand some of the definitions or the undefined terms that the Plaintiffs' Council had some questions about. He's been very open and engaged with me and us through the process. We're anticipating getting some further information from him so that we can. He believes that that the contracts are compliant, and based on those conversations, I think has that belief in good faith. I think he can answer questions about those definitions, probably to the monitor and plaintiff's satisfaction. Should they want to get in touch with him. I'm also hoping to get something in writing from him that I might be able to share with all of you, the monitor and the Plaintiffs' Council, to help assuage any future problems they might have with the current reading of the contracts.
I think it would be important for you to give us that information, Peter.
Yeah.
Just because workload compliance is a huge deal. And if we can have that information when we speak to folks in our own county and saying, yes, we are compliant or we're almost there, I think that would be really helpful for the board members.
Absolutely, and I'll get that to you as soon as I can. The couple things I would mention are Eureka County is sort of briefly without a contractor, as Deputy Director Sayar mentioned. After dealing with the county, we've got that resolved, so they do have a contractor in place. We'll have that finalized shortly, so there is no loss of consistency and representation there. We are right now, like I mentioned earlier, working with White Pine County to ensure we have appropriate coverage there. We've already been working with Jane Eber Hardy and Julie Kavanaugh Bill to continue their contract support of the NSPD in that county. We've been working again with Cale Brock in Lyon County. We're hoping to get more information very shortly as we're coming close to the Davis deadline. He's been good about working with us. He's been pretty communicative with us. So we're going to get more information about how case assignments are going to start changing in legal servers so we can identify which attorneys have which cases and identify if there are workload deficiencies. And then we're also going to try to see it may be that he has additional attorneys supporting him in addition to the 3 we have independent contractor kind of contracts for. We're going to be working with him to see what other information he can provide us to make sure that Lyon County comes into compliance. I'm also hoping to talk to to Josh Foley in that county and get a better idea of where he thinks the county might be going, considering there are some circumstances that may lead to representational issues in the future. One of the current contractors is running for district attorney in that county, so that might affect things come November. And we want to make sure there's a plan in place if that comes to fruition in favor of that person making that run. I will mention continuing good news, though, again, we've mentioned Nye County has 12 attorneys. That is in compliance. Obviously, now we shift our work to making sure that those 12 attorneys are actually applying the appropriate amount of time to their cases and their clients, such that the workload's actually fulfilled by their work, as opposed to just having a contract that says they will do it.
And I remember that you all were trying to get different staff members to different counties. Are you still working on that?
Yes, I will probably personally be traveling down to Nye County. I'm hoping sometime this month or early next month. Based on the changing circumstances, it might be that we're making our way out to White Pine County instead, and perhaps a few other places as well as we try to see things through.
Great. And any other questions or comments about the workload? Okay. Thank you so much, Peter.
Sure. I think Kate Thomas is jumping off. I'm not
sure
that affects our quorum at all. I don't know if you all were going to take any action on anything, but just to make sure that everyone's aware and so that our DAG might be aware, we might be reduced to having discussions only, not being able to take action items.
I don't think we have any action items left,
right.
Peter.
You got a better handle on my agenda than I do. Thanks.
Yeah. Now we just get a chance to each of us speak. Going to item number 8, are there board member announcements, updates, requests? Do we want to put any more work on Peter? Does anybody have anything? Joni?
Yes, I always do. Thank you, Madam Chair. And you're doing a great job, by the way. I just wanted to bring to everyone's attention, I've been complaining about the fact that Nye County is housing inmates in Pahrump from Esmeralda County, and there's no interlocal agreement or contract in place. There's nothing. Nothing's been brought to either of the boards of commissioners, and that's not a good thing, but that's not an issue for this group. But I was looking at Esmeralda County's agenda yesterday for their Board of Commissioners meeting, and there was an item for the county to enter into an MOU with Mineral County so that they can also take prisoners to Hawthorne. And I just want everybody to be aware of that.
Thank you. Any other board announcements or questions, requests? Okay, I can see.
Yes.
Oh, go ahead, Justice Moffin.
As to the billing business, it wouldn't be a stretch for us to put together a CLE program showing people how actually to contemporaneously record their time and without it being too onerous, which means a mixture of block billing and individual itemization of tasks performed. That having been said, these are the idea is to get as close to the actual amount of time each lawyer is working on the case. And that's one way of doing it. On another point, it appears over the years that I may have been remiss in not publicly recognizing the contribution that Christian Chiliani has made to our state. She has been intelligent in her work. She has been industrious. She has helped other public officials immeasurably. She falls in the category, in my opinion, of the Mary Gojaks, the Miriam Shearings, the Sue Wagners, the real heroes of the gradual break and all too gradual breaking of a glass ceiling in Nevada government. And so one of the things that you can always count on is whether you agree with her or not, and we have not always agreed on certain things, but whatever it is that she is offering, you can bet that you can trust her sincerity and her dedication to the people of the state of Nevada.
That's a very excellent comment. We all need recognition, and you just gave it. Appreciate it, Justice.
It was well deserved.
Absolutely. As long as we don't have to pronounce her last name, we're good. Thank you. Thank you, Chris. Really appreciate all of your work, and those of us who go back, some maybe farther than others, like Justice Maupin. We have seen your work, and we do appreciate it. Okay, let's move on to upcoming meetings. Do we have, does everybody have August 20th open? So it's it could be in person in Carson and a virtual option with Zoom.
Yes.
Can everybody make that? Go ahead,
Yes.
Peter.
I was going to say, yes, that's correct. We'll have it here at the office in Carson City. There will be the virtual option again. I think this is the best date according to the last poll we set out for the board members.
Are you serving lunch? Kate might like that.
Bring your own. Yeah, this is a brown bag lunch kind of situation.
Okay.
They are pretty close to Pete's Deli.
Yeah, we got a Bass place right across the street.
Oh, that's right. Bill a Bass. Okay, moving then to public comment. I know John Lambros wanted to jump in again and have his 3 to 5 minutes.
If I could, Madam Chair, since I'm the executive director, get a point of privilege and jump in earliest.
Oh, sure.
I just
Absolutely.
want to thank all of the attorneys and county folks and the staff at the NSPD's office who've been at this board meeting attending, like staying interested and staying involved with what we're doing, with what this board's doing, and always being really helpful in reaching out to us and working with us to make things better. I can recognize a lot of the names of the state public defender's office. I'm sure, that they're in a position where they're kind of worried about their future. And
right.
I hope they're not concerned, because we really do rely on them to continue the work for the clients. We think they've been doing an excellent job to the extent that they're able with the supports and resources they have, and they have our full support as we move forward through everything.
Right.
Thank you.
And hopefully we'll find a very good, qualified leader who will appreciate all the staff. Thank you. All right. Anybody want to jump in with public comment?
Yes, I do.
Thanks. Go for it, Franny.
Okay, this is Franny Forsman for the record. I think Chris got off of the meeting before Maupin made his comments, so I suggest maybe we transcribe that and send it to her. So the only comment I have is with regard to the legislative stuff. It sounds like Peter's already been doing some work on that. And I just wanted to say that the potential legislative changes may be implicated in either wrapping up the Davis case at the end of August or whatever may happen at that point. So however we can end up collaborating, on potential legislative changes with the work you've already done, Peter, I think would be helpful.
Thank you, Franny, and thank you for all the work that you've done. In big part, we're here because of you and your amazing work throughout the years, and how much you know about the biz and the needs of the clients. I so appreciate.
Some people do go back farther than others.
Right. Okay. Move to adjourn. Do I have a motion to adjourn?
Before you do that,
oh,
I think Franny's got a good idea. I was hoping that she would hear what I was about to say. So
right.
maybe send a transcript of this part of the hearing to her.
That sounds good.
Would mean a lot to me.
Yeah. And I know to her too. Okay, we're adjourned. Thank you all so much.
Nice
Good
work,
job,
Allison.
Alan. Good job.
Yeah, I appreciate your putting up with me. So thank you.
Thank you.
Take care. See you August 20th.
See you then.